Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Let's go to the most interesting one, or certainly most interesting one, to Indiana.
Well, yeah, it's certainly is. Let me just get my my latest.
And as you're pulling it up, let me tell all the viewers, we talked about this last week. We talked not because there was an actual fireman's rule case, right? We brought it up and talked a lot about the fireman's rule, and we're saying, isn't it possible it could have been raised then? And we talked about the fireman's rule, and here you go, 1 week later.
Yeah, and interesting case out of Fort Wayne. We had a Fort Wayne fire captain who was injured at a commercial building fire. The building was owned by a real estate company, Sweet Real Estate, but it was leased to a company called VO Ride, and they rented scooters. Now, I'm going to make an assumption here, but I'm assuming it's lithium-ion batteries. So I'm not positive, but I'm making that assumption. But at any rate, the fire, you know what? The complaint never mentioned lithium-ion batteries. So maybe it wasn't. I don't know.
It should have, because it's such a, maybe they didn't know it's such a high probability of starting these fires.
But at any rate, they got a fire that started in a battery, and a certain captain, Captain Richard Dolson, was injured when he, and the fire was in 2022, when he fell through. There was an unfinished wall where it just had studs, and he apparently...
And not properly spaced studs.
Right, they had removed one of the studs, so he must have been sort of feeling his way along in zero visibility, and then went through and fell down a stairwell and was pretty badly injured. So he sued the tenant as well as the property owner for negligence. And part of his allegations, I cut out some of the factual details. It got a little bit extensive there, but essentially he was alleging that they had the opportunity to warn the incident commander, and because he was in communication with the incident commander by radio, all the incident commander would have had to do was to notify him that there was a danger due to the missing stud, which it seems kind of a little on the precise side. But at any rate, that there was a danger. He was not alerted to that, and that the property owner and the tenant both had a duty to inform him of the danger, and that they were negligent, and negligent, number one, in removing the stud, and also number two, in not warning him about it, and therefore he was suing. The real estate company and VO Ride both filed a motion to dismiss, or motion for summary judgment, based on the fireman's rule that says that you're a firefighter, you go to a building, you get hurt, you're not entitled to sue anyone for that. You've got your workers' comp, and there's a lot of reasons for that fireman's rule. One of which is people may hesitate to call 911 if they think they're going to somehow create liability for themselves by calling. They may try to put it out themselves. And also, people pay taxes. Why should they have to pay taxes plus be subject to these kinds of suits? And assumption of risk, which you kind of mentioned before. So you have all those things kind of circling around in the background. The trial court agrees with the property owner and dismisses the case. Okay, and the Captain Dolson, then appeals to the Court of Appeals, and the Court of Appeals reverses and said that yes, Indiana recognizes the fireman's rule, and the fireman's rule prohibits firefighters from suing when they're hurt at an incident, but it's narrow, and every state's slightly different. This is what we talked about last week.
Yep.
Every state is slightly different on its interpretation of the fireman's rule. And in this particular case, they say Indiana's fireman's rule only applies to someone whose negligence caused the fire. And in this case, there is no allegation that the property owner or the VO Ride caused the fire. The negligence here was in how they were maintaining their property. Now, there's other states where this would be covered by their fireman's rule, but in Indiana, it's only limited to suing somebody who is responsible for causing the fire, whose negligence leads to the fire. And the Court of Appeals reinstated the case, and now it's going to go back to the trial court for further proceedings. So
yeah, and let me just kind of phrase it a different way, right?
Yeah.
Here, if you have a property in a dangerous condition, such that when a firefighter enters the property, they are deemed to be what's called an invitee, as the court suggests, a guest. And so when you intentionally or unintentionally invite someone into your house, right? In this case, unintentionally, but you still invited them because you created a condition that called them in, and you have a effective trap, a dangerous condition, you're going to be liable just like you would to any other guest. So I agree with the court, and I think it's probably more of the statutes, right? So firefighters' rule is normally created by courts, not statute. And then they bring in statutes, laws to get rid of the firefighters' rule or modify it in some way. And I agree with this court, maybe because it's what I'm used to, but yeah, if you cause the fire, you're not liable for that. That's accidental, right? But you don't owe a duty to anyone not to cause a fire necessarily. But when you have a dangerous condition on your property and you invite people in, you're responsible for the dangerous condition. And that could be ice on the driveway right? 3 days after the storm, there's still ice on the driveway. And look, I think it's right. I think it's fair, not just for the firefighter, but and we think this way as firefighters, not as public. You need to leave your house in a condition that there's a fire, right? I never block our exits. We sleep with the doors closed, right? In case there's a fire, the bedroom doors are closed. I mean, firefighters think of these things. We wouldn't leave a whole gaping hole in the middle of our house just because you could walk around it. We wouldn't start a motorcycle repair business in our basement. We generally think of, oh my God, there could be a fire, so let's leave our house in a condition to get out and so others don't get hurt. Most people don't think of it that way. But I go to Black Sunday. I go back to Black Sunday where it didn't turn out the way it should have. Let's be fair, right? The landlord should have been in jail and whatever. But where you cut up your house and you create such a dangerous condition to the firefighters, where going into a fire, it becomes very dangerous. They didn't know what it was supposed to look like. It wasn't in code. It was a dangerous condition. The landowner should be liable for that. I don't care whether it's the mailman who comes in, whether it's a delivery guy, whether it's your brother or sister, or it's the firefighter. You invite them in for any reason, intentionally or unintentionally, you should be liable for the dangerous condition you allowed to exist, period. Because you know darn well, when we don't go in because there are dangerous conditions, they sue us. Oh, I was a hoarder house, but so what? We're going to sue you. You didn't put out the fire. Well, guess what? Fair play on the other end. You invite us in, there's dangerous condition, and we go in, you should be liable. So firefighters are not using these types of statutes enough when they exist, right? I don't know if you've studied how many states have them, but we're not using these to our advantage enough because we're just not aware of them.
Yeah, what I do know, there's about a dozen states that have eliminated the firefighters rule. So
New York is one of them, and
so and I support that. I think that's the right direction. Not that we want to be overly litigious on every fire, but we want to make sure, because it serves a function in getting people to maintain their property. And I think that's what you were kind of getting at, that you can't be neglectful in how you maintain your property. And then say, oh, well, they as part of the risks of their job. No, some of it is. Certainly some things are within the risk, but there's other things that are outside of what we should have to encounter in our daily activities as firefighters.
Exactly.
So interesting case. So